Hey everyone, now that we've got the underpinnings behind the executive and the basics figured out, let's get into what the executive can actually do. So we're in Article 2 of the Constitution about the executive. So Article 2, Section 1, the very first part, says that the executive power shall be vested in a president of the United States, okay? The executive power shall be vested in a president of the United States. Then sections 2 and 3, the next two parts, have specific powers granted to the president, like how the Congress part had a whole list, okay? And it includes that the president can appoint judges and ambassadors, the president can veto legislation, the president can call Congress into special session, the president can grant pardons, the president is the commander-in-chief of the armed forces. So the big question is whether that's a list of everything the president can do in 2 and 3, or the president can do everything in 2 and 3, plus the president has the executive power. So I just want to make sure people understand this. The first part of Article 2 says that the executive power is vested in a president. So that means that a president carries out the laws. And then 2 and 3 say what the president can do, including he's the commander-in-chief and he vetoes legislation. So the big question is whether the president is like Congress, where that's all they can do, or he can do that plus he can execute the laws. So there's a big debate about this from the very beginning, where Alexander Hamilton had the plus version, where the president is the steward of the nation and leads the nation, and as long as the Constitution doesn't say he can't do it, then he can do it. Versus James Madison, who said, no, the president is like Congress, there's a list of things. If it's in the list, the president can do it, otherwise he can't. And what we've ended up with, as you all probably know, is the stewardship theory, where unless the Constitution says otherwise, a lot of the time the president can do it. And the president can do more, as you all know, besides be commander-in-chief and veto legislation. Obviously, Donald Trump does a lot more every day than just command armed forces and veto legislation and appoint judges. So we have a very big, expansive view of the president, like how Alexander Hamilton wanted. And this works again into the theoretical things we learned, where Alexander Hamilton wanted to have the people have as little control as possible, right? Since the president was elected by an electoral college, not the people. The president is only elected every 4 years, so it's a pretty long time. If you give the president a lot of say and a lot to do, and the president's a lot less responsive than members of Congress, right? Members of Congress need to be reelected. It's their careers. They're closer to the people. They come from each state. They are directly elected. It makes sense as someone who wants to have the people be less involved, wants a strong president who isn't even popularly elected. So the big case that ends up saying what we think about the presidency nowadays is what's commonly referred to as the steel seizure case. Now, the name of it is Youngstown, Sheet and Tube versus Sawyer. But again, like I said, when people talk about this, they're going to talk about the steel seizure case. And this case is from 1951. And what we end up having in this case is President Truman wanted to be able to seize the steel mills because they had to stay open for the war in Korea, okay? And what was going on was there was a chance that steel mill workers were going to strike, and President Truman said, the federal government is gonna seize these mills. We need them to make steel, okay? And the steel mill owners wanted to just keep control of their own mills. They were owned by private people, right? And what President Truman and the federal government said is that we have to do this, that this is the lifeblood of the armament industry and troops need to be protected, and that I'm not interfering with small businesses, but what happens is that I'm the president, so I'm commander-in-chief of the Army and the Navy. I have to look out for the welfare of soldiers, and it would be criminal to not support them with the tools they need. So basically, if these steel companies go on strike, I'm not gonna have guns, I'm not gonna have bullets. I'm the commander-in-chief of the Army, and I'm gonna be sending in soldiers without all the things that they need to stay safe. Now, the Supreme Court said no. The Supreme Court said that this is making laws, and only Congress can make laws that the president then carries out, okay? So what you end up having is a lot of ambiguity, though, in this decision about what's making laws and what's not making laws, okay? And a lot of people say it's not lawmaking because he's seizing individual mills because there's going to be a strike, and making laws is general things, right? Like nobody should steal. But if you're saying I want to punish this person for stealing, then are you really making a law, right? Our idea of laws are general things. And so if President Truman is just saying right now the federal government needs to control these particular things for the war, it doesn't really seem like making laws. But so what ended up being really famous from this opinion, and that I want everyone to know, is Justice Jackson's concurrence, okay? So what we're talking about now is Justice Jackson's concurrence in the Steele Seizure case from 1951. This is a very famous concurrence, and it's what we end up using to decide whether or not what the president did is constitutional, which means it's okay, and unconstitutional, okay? So there's gonna be 3 different categories, and from now on, we're gonna do this. This is what ends up still being the law, okay? So write down, star, wherever you want to, that this is still the law. That there's 3 different situations the president can find himself or herself theoretically in, okay? So the first is that Congress authorizes a president to do it, okay? And this is where Congress makes a law and says, President, you carry it out. So Congress makes a law, for example, saying marijuana is illegal, and says, President, you enforce this law. We want you to make federal drug agents who arrest everyone who sells marijuana, okay? That is where Congress explicitly made a law and told the president to do something, okay? Now, if we're in this first category, almost always it is gonna be constitutional, okay? If we're in a situation where Congress said, here's our law, president, go do it, the president doing it is gonna be constitutional as long as Congress was able to do it, okay? If Congress is saying something they can't do, like president go in and, I don't even know, like arrest everyone for littering or something that isn't interstate, then the president can't do it. But if a law is constitutional and Congress tells the president to do it and the president does it, it's gonna be okay. So then the second category is where Congress didn't do anything. And this is what's called the Twilight Zone. And basically all the cases that we're gonna learn in the rest of the section on the presidency are these Twilight Zone cases. And this is where Congress didn't make a law, so can the president do it? So that's where we are here in this case, okay? Congress didn't have any laws about whether or not steel mills need to stay open in wartime. So can the president make steel mills stay open in wartime? This is gonna be the question we're gonna wrestle with. So when you're in the second category where Congress is silent or that Twilight Zone, it could go either way. Sometimes we're gonna end up saying it's okay for the president to do something where Congress is silent, and sometimes we're gonna say it's too far. And then the third category is where Congress has said no, okay? And this is where Congress either made a law that says to the contrary, or that'd be explicitly or implicitly said no. Now, explicitly, Congress saying no is going to be easier. For example, if Congress had a law saying steel mills can close whenever they want to, and then the president tried to make them stay open, that'd be unconstitutional. But implicit, which is where Congress didn't actually say anything, but it seems like they said no, is where this is going to be tricky. And that's what happened here, where Congress had thought about making a law saying that the president can seize steel mills, but it didn't pass. And so what you have in this concurrence here by Justice Jackson is he says that here we're in number 3, where Congress literally told the president not to do this because Congress thought about having a law that would let the president seize steel mills, didn't pass it, so they're telling him not to do it. This is something you can talk about in the comments, but it's very hard to know. It's really tricky. There's a lot of reasons why things don't pass Congress, and if a law doesn't pass Congress, it's not necessarily clear that what they're trying to do is tell the president no to something. But so I want to sum that up because we're going to go through this a lot. So again, there's 3 different ways that the president and Congress can be acting. The first is where Congress explicitly tells the president go do something, and pretty much always then what the president does is going to be constitutional. Then the second is Congress is silent, doesn't say anything about it, and then it could go either way about whether or not the president can constitutionally do something. And then the third is where Congress told the president no, either explicitly made a law saying no or implicitly by debating a law and not passing it. And if Congress says no, then very infrequently is the president going to be able to do it, and it's almost always going to be unconstitutional. So that's where we are in the 1950s, and the next video is going to start taking us closer to the present.